We will hear argument this morning in Case 24-621, National Republican Senatorial Committee versus the Federal Election Commission. Mr. Francisco.
Mr. Chief Justice, and may it please the Court. The coordinated party spending limits are at war with this Court's recent First Amendment cases. The theory is that they're needed to prevent an individual donor from laundering a $44,000 donation through the party to a particular candidate in exchange for official action. But that Rube Goldberg theory fails for the same reasons this Court rejected it in McCutcheon. First, it's unlikely to work because the donor has to cede control of his money to the party committees, which have their own interests. Second, it's already prevented by other things, including the $44,000 base limit, the earmarking rule, disclosure requirements, and the bribery laws. And third, there's no need for it, since a would-be briber would be better off just giving a massive donation to the candidate's favorite super PAC. That's why no one has identified a single case in which a donor has actually laundered a bribe to a candidate through a party's coordinated spending, even though 28 states allow it. All this is why my friend tries so hard to argue that this case is moot. But that fails too. He has to show that it is impossible to grant either Vice President Vance or the committees any effective relief. But there's no evidence that the Vice President has abandoned his intention to run for federal office in 2028. To the contrary, he has an active statement of candidacy, an active Senate campaign committee that's already raised $50,000 in this year alone, and at least 15 of the last 18 vice presidents have gone on to run for the presidency. And regardless of the current executive's views of the First Amendment, it would be insane for Vance or the committees to knowingly violate this law, since it is a criminal statute with a 5-year statute of limitations. So this case remains alive and well. I welcome this Court's questions.
Well, Mr. Francisco, the RNC is not here. I think you would have to explain why the Republican groups here fit the bill of a national party.
Well, for a couple of reasons, Your Honor. I think, first of all, I actually think you can set the committees entirely to the side and focus just on Vice President Vance. And I take it your question is addressing 30110, so I'd like to explain that. The Sixth Circuit plainly had both Article III jurisdiction and statutory authority at the time it ruled solely with respect to Vice President Vance. When the Sixth Circuit ruled, the Vice President had not yet been elected to the Vice Presidency. He was still a sitting United States Senator. So even under my friend's position, he would be within the Article III jurisdiction of the Sixth Circuit.
I'm comfortable with him. It's the committees that I was interested in.
Oh, sure. And I can get to the committees. Just to finish up that point, I think even if you didn't have the committees here, you would have jurisdiction solely with respect to Vice President Vance. Now, as to the committees, the first point I would raise is that they've waived this issue. The first sentence of 30110 simply sets forth the cause of action, as then Judge Kavanaugh made clear in his dissent in the grocery manufacturers case on the D.C. Circuit, which this Court later adopted, that can be waived. But even if you turn to the text and look at what it means to be a national committee of a political party, this text makes quite clear that that phrase includes the national congressional campaign committees, and it doesn't matter whether it begins with the word or the word the. If you look at, for example, the 2018 amendments, they repeatedly refer to the National Committee of the National Committee of the United States as including the National Congressional Campaign Committees. And if you look at the BICRA amendments that were added in 2002, and specifically I point you to 30125B2B42, that's a mouthful. It specifically refers to the National Committee of a political party as including a National Congressional Campaign Committee. But I think my more important point is you could disagree with me on everything that I said with respect to the national committees. The Sixth Circuit plainly had jurisdiction over Vance at the time that it ruled. Now that we're in this Court 30110 doesn't really matter because it doesn't apply to you. All that matters in this court is that you have jurisdiction under the certiorari statute, which you plainly do, and Article 3 jurisdiction over the case, which you do not only with respect to Vance, but also with respect to the committees who are also being harmed by this statute.
So with respect to the vice president, what does he mean when he says, in effect, that it was way too early to decide whether or not to run?
Your Honor, I think that what he is doing is what virtually every candidate for the presidency does, is wait until after the midterm elections in order to announce his specific intentions. But I think it's important to remember here that the question is mootness. And when it comes to mootness, they bear the burden of showing that it's impossible to grant any relief. So they have to show that Vice President Vance has actually abandoned his intentions to run for federal office. But here, we know a few things. We know he's got an active statement of candidacy and an active Senate campaign committee that's not sitting around doing nothing. It's raised $50,000 this year alone. We also know that virtually every vice president goes on to run for the presidency, particularly young ones like Vice President Vance. And with respect to my friend, this court doesn't have to blind itself to the reality that's obvious to everybody else.